Have you ever wondered what happens to a jointly owned asset, like a house or a bank account, when one of the owners passes away? It is a common question, and the answer can significantly impact how assets are passed down. Joint survivorship means that when one owner dies, their share of the asset automatically transfers to the surviving owner or owners, bypassing the probate process entirely. This mechanism ensures a smooth and often immediate transfer of property. The core reason this happens is due to the legal concept known as the right of survivorship. When an asset is held in joint tenancy with right of survivorship, or as tenants by the entirety for married couples, the ownership is seen as a single, undivided interest. It is not that each person owns a specific percentage, but rather that they both own the whole property together. Upon the death of one joint owner, their interest simply vanishes, and the surviving owner's interest expands to encompass the entire property. This is a powerful feature because it means the asset does not become part of the deceased person's estate that needs to go through probate court. Instead, the surviving owner typically just needs to provide a death certificate and complete some paperwork to formally update the title or account. This automatic transfer is a key difference from other forms of co-ownership, like tenancy in common, where a deceased owner's share would pass through their will or state intestacy laws. For individuals planning their estates, understanding joint survivorship is crucial. If you intend for a specific asset to go directly to a co-owner without delay, then holding it with the right of survivorship can be very effective. However, it also means that the asset will not be distributed according to your will for that deceased owner's share. This can be a concern if your will specifies a different beneficiary for that property, as the joint survivorship designation will override your will's instructions. It is important to regularly review how your assets are titled to ensure they align with your overall estate plan and your wishes for your loved ones. This is especially true for blended families, where you might want to ensure assets go to children from a previous marriage, which joint survivorship with a current spouse might complicate. A common pitfall to avoid is assuming that simply because you have a will, all your assets will be distributed as stated there. The titling of assets with rights of survivorship, as well as beneficiary designations on accounts like life insurance or retirement funds, are non-probate assets. These assets pass directly to the named survivor or beneficiary, regardless of what your will says. Understanding this distinction between probate and non-probate assets is a fundamental concept in estate planning. It highlights why a comprehensive approach, considering all types of assets and their specific ownership structures, is so vital. Ultimately, joint survivorship offers a straightforward way to transfer assets upon death, often avoiding the time and expense of probate. However, its power to bypass a will means it must be thoughtfully considered as part of your broader estate plan. By understanding how your assets are titled and the implications of joint survivorship, you can proactively ensure your property is distributed exactly as you intend, providing peace of mind for you and your family.